present today on behalf of both ourselves and Focus Ireland. I think, given the shortage of time, I'll make 3 points, and I think there's going to be a lot of repetition in this room today, because I think there are the 3 really critical points, which are the provisions, as set out, is borrowing from social protection legislation, and there are so many differences between the administration of social protection and the administration of housing that I think there needs for bespoke legislation if this legislation is going to go forward, and a consultation process is absolutely warranted by the department in terms of developing this legislation. Secondly, a stated aim of the proposed legislation is to establish consistency in how state entities access social entitlements, the lack of a statutory provisions regarding decision making and the appeals process within the heads of the Housing Bill stand in contrast with such provisions outlined in the Social Welfare Consolidation Act, again reinforcing that need for bespoke legislation. Finally, I think we need to emphasise that there is an experience of local authorities requiring eligibility to social housing to secure access to emergency accommodation for which there is no legal basis. We would strongly submit to the committee that there is, at a minimum, there is a need to explicitly set out in the primary legislation that the habitual residency condition for the purposes of social housing does not affect and should not affect an individual's or a household's eligibility for access to emergency accommodation.
Okay, Mr. Denigan, please.
Thank you, and thanks to the committee for the opportunity to address you here. There'll be a lot of repetition, all right, as Wayne mentioned. Focus Ireland and the Simon Communities of Ireland welcome the opportunity to contribute to the committee's pre-legislative scrutiny of this legislation, which we believe would have really harmful consequences. The proposed legislation is presented as merely bringing housing legislation into line with the existing welfare legislation, and is therefore of no great consequence. However, the welfare and housing systems operate in very different ways, and introducing this approach to housing could do far-reaching harm. If enacted as proposed, it would result in many more people being denied shelter and so forced to sleep rough. There are 4 main reasons for this conclusion. Unlike the social welfare system, the housing system has no effective appeals mechanism, and the decisions of housing officials are effectively final. Secondly, the lack of accountability is particularly problematic because habitual residence is a legally complex area where local authority officials currently do not have that expertise. And under the proposed legislation, rather than deciding eligibility on the basis of assessment, an official may decline to make any assessment at all. These proposals link directly to rough sleeping because local authorities regularly decide not to offer individuals and families shelter on the basis that they are not eligible for social housing. This legislation does not deal with any of the really pressing issues, whether intentionally or otherwise, and this proposed legislation would result in more vulnerable people having to sleep rough. In addition to ill health and risk of death, this would have a serious detrimental consequence on our towns and cities and deepen social divisions. Our full submission proposes some amendments to ameliorate these harmful consequences, and I direct the committee to that. Thank you.
Thank you very much, Mr. Denigan. And
what we're saying is that before the proposals are moved forward, there should be thorough consultation with the likes of the bodies that we've already mentioned, in particular Oireachtas, who've done a huge amount of work in this area.
Okay. And
Mr.
I would say, yeah.
Actually, to make a very similar point, the objections here aren't to having legislation. The objection here is to having bad legislation that isn't bespoke, that doesn't recognise. This is an attempt to move across social protection legislation to put in a framework that allows the circular to operate, whereas what we're talking about is actually what's needed is bespoke legislation that deals with the issues created by the circular in the system currently that will actually help us to move forward. And there's an opportunity for the committee to do that.
An appeal system for this has been raised by everybody here, that there should be an appeal system. Do you have a suggestion of who should be the body to deal with that appeals system? Because I really don't want to have to set up another body to deal with that. Is there somebody that you can think of there that's, ready-made to deal with this?
I think Mike drew the comparison, given that the comparison has already been made with social welfare legislation. The benefit of having a sort of within perhaps the department, a designed body who has an administrative duty to look at these appeals, is you build up a body of knowledge. Deputy O'Brien talked about, talking about long-term need. The fact of somebody applying for social housing could contribute to your assessment of their intentions into the future. So if you're in social welfare making a determination and you look and say, okay, they've applied for social housing, that would be a part of looking at the assessment. So these things are semi-judicial processes. And I think that's where the complexity in all this comes from, is that it's very hard for administrative systems to look at that level of complexity. Administrative systems like hard and fast rules, EU legislation around and other legislation around reckonable residency and right to reside and all those things are some, particularly when you start getting into the 5 factors, you have to balance all these things. So you're going to get good decisions and bad decisions. If you're going to introduce that, you have to introduce a mechanism that you can appeal, and what you want is all those decisions to go to the one body, and you build up a level of expertise, and over time you will get less and less poor decisions.
But that should reside within the department, is that what I heard you say?
I'm not being prescriptive about it, because we haven't had time to give it full consideration, but probably you would do it in the department, because if you were to set them up in each local authority, you wouldn't get that level of, with the possible exception of the Dublin region, you wouldn't get that level of consistency of process, and you'd have a disparate system all over the country.
Okay, maybe it's a question we can put to the department then.
What do you think is the motivation of the government in relation to this legislation? In 2 or 3 sentences, we'll start with yourself.
Can I ask a quick supplement to Victor's question?
Yeah.
Just the more I'm listening to this, given it takes 6 to 14 years to get a social house, is this really about HAP eligibility? Is there somewhere somebody thinking there's a group of people who are getting HAP who aren't really interested in long-term social housing, and they're the people we want to exclude from the system?
I'm not clear, and I think what stands out for me is why this, why now? The circular is in place, for all the problems that it is. I mean, what we're talking about here is solidifying the current circular as opposed to addressing the issues that we've all been raising here. And there is things like the Simon Homeless Prevention Bill that many people in this room supported that could be coming forward now. And I think at the time of the crisis that we're in, I'm not fully clear why why this has become so important and is being brought forward so swiftly, or it appears without the level of consultation that we might often see. But I wouldn't. I think we work quite closely with the department. There's very good people, and there's very good people in local authorities. So I'd be slow to, put negative connotations on it. But I think the consequences of it, I don't think have been thought through.